Good morning and welcome to AM News Network presents the Morning Report with Rachel Baird and Ed Peruta. Ed is out today, and we did not do a show yesterday because, as many of you know who follow Ed on Facebook, he had to go to the hospital over the weekend to have his medication, as it turns out, adjusted, and he's back home and doing fine, and we look forward to having him back maybe as early as Saturday for our summary judgment show. But meanwhile, we have a lot of First Amendment news today. Yesterday at 9:30, the Supreme Court, the United States Supreme Court, as usual, issued its opinions and any orders and indicated whether it was taking any cases, granting cert. We were watching primarily to see if Peruta v. California was going to be taken up by the Supreme Court. And once again, we did not hear anything. The case has been relisted again, and we understand it's going to be discussed this Thursday, and maybe next Monday we will know something. There are two canines in the world, at least following the case, and they have a question that many humans have had as well. How did it turn to be from Peruta v. San Diego, oh, that's a close-up of a nose, to Peruta v. California? Now, the dogs' names are Bassie and Daisy. So Bassie and Daisy, the best I can explain it to you is that at the beginning of the case, when Ed Peruta sued San Diego County, California decided not to get involved. We like to think that they thought the case was such a slam dunk that it wasn't going to be an issue, that they underestimated the import of the case and didn't get involved. When it got up to the Ninth Circuit and a three-judge panel found in favor of Ed 2-1, that's when California all of a sudden, late to the game, got involved. San Diego, my understanding is, wasn't that interested in appealing, didn't appeal, and California took over the reins. So now the case is actually called Peruta v. California. California has taken the place of San Diego because even though the case was brought against San Diego, it has statewide implications. So Bassie and Daisy, that's the best I can explain it to you. I'm sure an academic or Second Amendment scholar could explain it maybe better, but that's the best I can do this morning. Now, two other cases issued opinions out of the United States Supreme Court yesterday, First Amendment cases that sided, you could say, with the First Amendment. One of them had to do with an individual named Simon Tam, who went to the U.S. Patent and Trademark Office to register the name of his band, and he wanted the name of his band to be the Slants, and that's Slants. They acknowledged, Tam and his band acknowledged that the term slants is often regarded as derogatory to people with Asian ancestors. And I'm reading, just to give credit where credit is due, from an analysis by Amy Howe, Howe. She is an independent contractor with the SCOTUS blog, and she actually live blogs every... Good morning, Dan.
Good morning.
Master Control, you decided to join me.
Managed to kind of slip in there.
Yeah, while you're out here's the blurb on Packingham versus North Carolina. This is the next First Amendment case we're going to be talking about. But let me get through Tam. Basically, what the Supreme Court found, it was an eight-justice opinion. Gorsuch did not participate, but the court invalidated the disparagement clause on First Amendment grounds. And what the disparagement clause is the U.S. Patent and Trademark Office does not allow, or did not allow, individuals to register names that were seen to be as derogatory, have negative connotations to, a group of people based on their race, national origin, or color. And the United States Supreme Court said that violates the First Amendment. And obviously it goes into an analysis. But the point is, case yesterday, Tam versus U.S. Patent and Trademark Office came out in favor, you could say, of the First Amendment. And the case you have in front of you, Packingham versus North Carolina, That's a case where my understanding is in North Carolina there was a blanket law against sex offenders having access to any social media where minors may participate. And of course that includes every social media, you could say, because minors are probably the ones who participate the most in this kind of stuff, you could say. They're growing up with it. And so I think this was a Facebook issue, maybe Twitter issue, Facebook. And the Supreme Court held that that infringed on the sex offenders' First Amendment rights, just the blanket prohibition on participation. My understanding is that in this particular case, the sex offender went on the Facebook and posted that he had been able to get out of a ticket the previous day, a speeding ticket. He was, in a congratulatory mood and was congratulating himself on doing that. So 2 First Amendment cases yesterday out of the United States Supreme Court, and I invite you to read them. Sorry I don't have more details on them, but I did not have a chance to go over them yesterday and analyze them. But that's why we go to people like Amy Howe, Howe, at SCOTUS blog, because this is what they do, and they do it best.
I was just going to ask, Amy Howe, does she work for SCOTUS and does this kind of as part of her job or on the side or informally?
Funny you should mention that, because I went to the blog and I looked at the people who work for the blog, and on the right she's listed now as an independent contractor. So she does her own thing. She has her own website, her own Supreme Court analysis.
Yeah.
But I think she used to work for SCOTUS blog, but she's transitioning to a certain extent.
She seems to have, I hate to say like inside access, but she does seem to have some kind of an access that that others, I guess maybe everybody does. And if you want to follow and you want to dedicate the time and have the knowledge.
Well, that's what it's about, dedicating the time.
Now, that's an interesting number to be calling in.
Well, let's answer it. Good morning, Ed.
Good morning. I see that you have my silhouette, my big picture there, so I am on the set.
Yeah, how are you doing?
I'm doing good. I'm sorry I wasn't available yesterday.
Well, that happens.
I know. Listen, Rachel.
More often than we'd like.
The case about the patent office.
Yes.
There have been numerous occasions throughout the country where people have attempted to acquire a vanity license plate for their car, and the state has refused to issue certain vanity plates because the state thinks that it's offensive. So this may also have an effect on whether or not people can get a vanity plate from the state of Connecticut.
Say maybe like a 4-letter vanity plate, that type of thing?
Yeah, like Malloy, get out of this state. If they have enough letters, Malloy, leave Connecticut,
Amy Howe ends her analysis by saying that this could have much wider impact, just like you brought up, Ed. And there's a case going on right now concerning the Washington Redskins. There is a Native American group that has been seeking to force the Washington Redskins to change its name, and the Redskins have been fighting that. And a lot of, Amy Howe and I assume a lot of other people are thinking that this case, TAM versus United States Patent Office, is going to help the Redskins in their fight to retain their name now.
Yeah, I mean, people have been...
In the Redskins case, the patent office actually canceled the patent on the Redskins and the logo and everything else. And football teams make a fortune selling hats and shirts and everything else. So there's big money involved in the Redskin issue.
Yeah. And then it says a lower court upheld the cancellations, but today's ruling will breathe new life into the team's challenge to that decision. Go ahead. I just wanted to get that last part in.
Yeah, I mean, I think people have tried to shame the Redskins based on just kind of, social pressure and the financial pressure with sponsorships pulling out, and really have tried to shame them into changing the name. And I really I have a respect for the fact that the guy stood firm to say, look, this had absolutely nothing to do with...
Look, hold on, guys, hold on. I had some people here with me last night, my daughter and my granddaughters, and they're getting ready to leave, so I have to pay attention to them, but I'll try to call back in a little while.
Okay, thanks for calling, Ed.
Okay, bye.
He's the one that called us.
I was trying to figure out the transition. I don't know, maybe they're Maybe they're Native Americans. I don't know. No.
I think they're on their way to school. I think school's
No.
about ending. Maybe today's the last day. But no, Dan Snyder is a fighter. There is no doubt about it. The owner of the Redskins. He's always involved in something.
My alma mater, at the time Bryant College out in Rhode Island, now called Bryant University, used to be the Bryant Indians, and Bryant was shamed by the same reason into changing. They basically caved into the kind of social pressure, and now they're the Bryant Bulldogs, which one could say maybe Bulldogs find it offensive.
Yeah, but you know what? It's an individual decision. If you are a business entity and you're doing something and you feel like the cons outweigh the pros, then it's your decision to change it. There's actually nothing wrong with bowing to that kind of pressure. And there's nothing wrong with not bowing to that kind of pressure. It's a individual business decision on what to do, the way I see it.
Right. Now, it's interesting as well. I know that you went to spend some time down in South Carolina at the University of South Carolina with the Fighting Gamecocks.
Yes.
And my daughter's about to start her senior year shortly there. And there are people who have tried to pressure them to say, that's inappropriate. But that's, I think really it's kind of a part of the South, right? I mean, maybe.
Well, what is it now? Gamecocks. They people actually put them in rings and they fight with each other,
and
right?
They fight to the. If you look at the logo, they have razors on their talons on their ankles, and they've I've never been, so I don't know. I mean, my understanding is that they in some cases fight to the death.
I would be surprised if you told me you had been to something like that.
Yeah, I've been to a bullfight.
Yeah, a bullfighter got killed the other day. Did you see that?
No.
Oh yeah, the bull fell. I mean, I guess it was in Spain, not in America, but the bull fell on him and gored him, and he died.
Oof.
I got to tell you, it's hard for me to feel sorry for bullfighters when that happens, because to me they're putting themselves out there, and plus that poor bull. Usually it's the bull that gets killed. So I should feel bad for the loss of human life, and I guess I do. But on the other hand, it's like, stop it, stop doing that.
I do remember. I mean, I say that half joking, like, "Hey, I went to a bullfight. It was the most gruesome."
I know.
The bull never stood a chance.
Right.
I guess I had thought prior to that, like, oh, it's kind of skill and everything else. They don't. I mean, they torment the bull, and there's a whole process in terms of just letting the blood out. And by the time that bull could barely stand, and the matador goes and does his thing, and it was gruesome. And something I won't want to run to anytime soon.
No, it's probably the David and Goliath thing. Since the bull always loses, when the bull wins, you got to feel good for him. But on the other hand, when he wins, that means a person dies, so you shouldn't feel good for it.
Yeah, I mean, there's videos I've seen where the bull, somehow gets a jolt of energy, and hops the fence and jumps up into the stands, and and then everybody's screaming, "Oh, this is terrible!" And I'm like, well, you all came over to see this, so. But anyhow. So somehow we transitioned from SCOTUS blog to, bullfighting.
I don't know how we did that. So two great. If you're a supporter of the First Amendment, which we are here at the Morning Report and AM News Network, then take some time and read those two decisions out of the Supreme Court yesterday. Because although the justices agreed, they agreed for different reasons. Now, more at a local level. There was an opinion published in State of Connecticut versus Haral Patel yesterday, and the opinion had to do with this whole scenario that occurred back in January of this year, and it seems like ages ago at this point, where American News had permission, was allowed to record a trial that involved a murder, home invasion that occurred in Sharon, Connecticut. There were certain orders that issued by Judge Danaher of what American News could and could not tape in the courtroom. And Dan, you participated in some of that, didn't you?
I was up there on a couple different occasions, running the camera, filming, and certainly for the sentencing, which was really difficult to sit through and hear the witness statements and families and all that type of thing. Something I hadn't done.
And it was long too, wasn't it?
It was. Yeah. It was. I was very surprised. I mean, I thought, certain times you get an assignment, you go, you sit, you run the camera, and but to hear, this isn't TV. This is real life, and the emotions from the folks, and it was difficult. But I do remember, the discussion here in the office about this whole issue of, Ed trying to show up just to get the exhibits. And, the stuff that we ended up talking about yesterday after the opinion was released about, the prospect, had the decision been allowed to stand the way it came down, everybody else in the world, essentially, in the state, would be precluded from going and getting the exhibits merely because American News wanted to exercise the right to cover the trial.
Yeah, I want to get back to the sentencing comment you had, though, because it really goes to the heart of why we do or want to do more of what we do in the courtroom. And that's because on the news, if there's coverage of a sentencing, they're only going to show you little clips of it, little snippets of it. It's only when an entity like American News goes into the courtroom and films the entirety of the sentencing that other people, not only you, because you were there, but other people who were not there can see the whole thing and say probably the same thing you said. Wow, I never knew it was like that. I've never had the opportunity to see a whole sentencing and how emotional it can be and how many lives are impacted by a criminal trial and the conduct that led up to the criminal trial. And this is our goal, so people can see that. And it seems like a lot of times it's the goal of the courts and the participants in the trial to keep as much of that from the public, so the public can't see it. And I don't understand that fight.
Well, I thought of that when I sat down at this table and you slipped this opinion from the Supreme Court of the United States. And people can't see, of course, but, Rachel gave credit to Amy Howe, and there's, I'm not sure how easy it is to see that. But here's this opinion, and right in the middle is, the little sketch from this artist whose name I can't read off to the side, Liem, perhaps, I think. A sketch of Justice Kennedy. And it reminds me that, even in the Supreme Court of the United States, that they still do not allow cameras in this day and age. Now, I find fascinating and quite informative and educational for me, especially somebody who's for a prolonged period of time been a self-represented litigant. I have listened to easily hundreds of oral arguments in the Supreme Court that are on their website. Hundreds. Some of them I've listened to over and over and over again, to the point where you get to easily recognize the justices' voices, learn how counsel addresses the bench, learn how they respond to questions, and it's invaluable. And to me, the ability to see that video would even be better than just listening to the audio.
And unlike trial courts, I mean, at the Supreme Court, there's not testimony by medical examiners or victims or the things that supposedly the courts and the parties are concerned about when you're in a trial court. I mean, these are briefs and oral arguments that, like you say, are put out in whole on audio anyway. So what is the reason why video is not allowed? I think some of it has to do with the mystique. Once you open the Supreme Court up to video and everybody can watch what goes on there, a lot of the mystique goes away. You kind of pull the curtains back on the Wizard, on the Wizard of Oz, and people see that these people, these justices, are just people. And excuse me, but sometimes they ask stupid questions like anybody does. They're not perfect. They're not the smartest people on the earth that have ever been invented. When you pull the curtain back and allow people to see that, I think that the courts want to hold on a bit to that last bit of mystique that the Supreme Court has. But it's been going away anyway, because a lot of people realize, especially after this recent election, how political the court can be.
Well, I think the other thing, with the Supreme Court as well, and, in this day and age with high-definition video, it certainly does get tricky in that if what I'll call mainstream media wants to pull out a one frame or a couple second clip, they can really make somebody look quite foolish. You can get, let's face it, if you're sitting on the bench for hours listening to argument in multiple cases, there's going to be a moment where somebody may yawn, or they may sneeze,
or fall asleep.
they may scratch their nose, and as human beings, they may end up looking somewhat foolish if somebody decides to isolate that one clip, and now that becomes the thing that goes viral and says, well, geez, look at Justice Kennedy. Can't even stay awake. And that would, and so some respects, I think I understand it.
Well, I don't, because they're people just like anybody else, and Donald Trump is the president of the United States, and look what he is subjected to. And so if he's subjected to that kind of scrutiny, I don't know why the justices shouldn't be. I don't know why anybody in the public eye who is making decisions that affect so much of the public shouldn't be subject to that. But our great hero, Justice Scalia, was dead set against cameras in the courtroom, and I disagreed with him on that one point, that's for sure. Hi, Ed.
How are you doing?
No, we're still here, plugging our way through.
Well, let me give my opinion on the appellate court decision in the Patel sentencing issue.
Did you get to read it?
I have not. I will be reading it this morning. I believe that the powers to be in the Litchfield County Courthouse were coming up with rules du jour, in other words, rules of the day. They were winging it. They were trying to do things that were clearly not permissible. They were attempting to editorialize the video that was shot, editorialize the impact of the victim statements. They were, in fact, going directly against what the Media Committee for Judicial had attempted to do. And the Media Committee, I believe, after a long period of time, historically in Connecticut, had permitted cameras to go into the courtroom so that the public could see in its entirety what was going on in our courts. Now, there's going to be a new courthouse in Torrington. And I understand the limitations of the old courthouse in Litchfield proper, in the borough of Litchfield. But the question is the court going to permit a quality video record of the trials that take place in Torrington? And I know for a fact that the victim's advocate in Litchfield County Courthouse has an animus towards American news, towards me, and towards the recording of trials, because one of the conditions was we could not videotape the victims of the incident, i.e. the mother of the deceased child. Well, when her impact statement was read to the court, it was read by the victim's advocate, not by a victim. And that should have been allowed. But I know that there is animus. That woman has made statements negative to American news, negative to me personally, and it's going to catch up with her if it continues.
Well, I mean that's the issue. When people make statements, they are sometimes not aware that the people they're making the statements to may or may not necessarily agree with them, and although they don't say that, they do pass that information on, and so information does come to us about things that are said about American news in the courtroom and I think that's what you're talking about. But I want to get to some of the highlights of the decision yesterday. This was my favorite part because I don't hear it enough. I guess no attorney hears.
Hang up and listen.
I guess no attorney hears this enough. Maybe no human being hears this enough. Oh God, this.
Nope.
Oh, is it incoming?
Nope. I'll take care of it.
Oh, thank you.
Keep
Because
going.
you're master
Yep.
control. But we were the petitioners in this case. On the basis of our review of the record, we agree with the petitioner. Boy, that feels good. I got to tell you, you can't say that doesn't feel good.
I don't know.
We agree with the petitioner that the court improperly limited the disclosure of judicial documents without adhering to the procedural safeguards required under our rules of practice. Accordingly, we vacate that portion of the court's order preventing the petitioner from obtaining copies of trial exhibits. and direct the court to follow the procedures set forth in Practice Book Section 42-49A prior to rendering any new order limiting disclosure of exhibits. And what the court's saying is there's a procedure for addressing what can be recorded in the courtroom, and there's a procedure for addressing what documents should be sealed and not disclosed to the public. And the two procedures are entirely separate. You can't mix them, and that was exactly our point. Now, Dan, your point was, and this was sort of a point from a common sense point of view, when the court limited the disclosure of exhibits from the clerk's office because of the order issued to American News regarding videotaping in the courtroom, basically what happened was, because American News wanted to videotape in the courtroom and the order about the exhibits flowed from that, the order about the exhibits not only affected American News, but affected everybody in the world.
Public at large, right.
So by American News taping in the courtroom, what we could in fact have caused was a lack of access to everybody in the world to exhibits that they otherwise would have had access to.
Right. It was kind of the reverse effect. American News was trying to encourage and share openness, and it actually caused a closure, a more restrictive.
At least for a period of time. And let me tell you, the state may appeal this to the state Supreme Court. We don't know. So this is only the mid-level appellate court. It could change. And this gets to what you were talking about. Let me see. In the present case, the court issued its order preventing the petitioner, as well as members of the public, from obtaining copies of certain exhibits in the absence of the petitioner's attorney and without prior notice to the public. In other words, not only did American News not have an opportunity to be heard on this, but the public didn't have an opportunity to be heard. Accordingly, neither the petitioner nor interested members of the public were afforded an opportunity to be heard. The court did not articulate what overriding interest it sought to protect by limiting the petitioner's access to copies of exhibits, and made no specific findings underlying its order, including listing which exhibits were subject to the order. That was my question, too. We had no idea which exhibits we could get or not get. Because the court clearly failed to follow the procedures set forth in the practice book, the petitioner is entitled to relief. The petition for review is granted, and that portion of the court's January 25th, 2017 ruling on the petitioner's motion to clarify, indicating that the petitioner is not entitled to obtain copies of trial exhibits, is vacated. Any subsequent order limiting the disclosure of materials on file with the court must comply with the requirements of the practice book. And that's all we ever asked for.
Now, I guess the one thing that wasn't clear to me until just now is thinking, how was it that the denial came? Was it somebody showed up to get them? Had the judge issued an order saying, no, American News can't get the exhibit? Or was it merely a kind of what I'll call a barrier or a blockade at the clerk's office attempting to get them?
The decision goes into that. Ed went to get the exhibits.
So he went to the clerk.
Like he had done in January of 2016 in Patel 1. There were two people named Patel who were involved in the same incident, and they were tried exactly 1 year apart, so it can get a little confusing, and we videotaped both of them. So he went to get the exhibits. He got them last year with no problem, and so he went this year, and the clerk told him he couldn't get them because Judge Danaher had said so. And I said, well, where's that order? Well,
that's what I was going to say. In terms of them reviewing the record, where does it show in the record? I mean, I'm sure maybe he goes and whoever happens to be working the desk that day, and then maybe I didn't know that, he goes to personnel number 1, and then they say, well, hang on, let me get the head clerk. And so, Brandon will come out and then say, well, no, the judge said, or somebody maybe goes and checks with the judge, but where is it on the record? Does that,
good point.
Is that in the record for review, that the judge said no?
Good point, because you're right. You do have to make a record. You just can't go appeal something on,
I was told,
on conversations in the hallway. We filed a motion to clarify. That's how it happened. I filed on the record a motion to clarify, what are you talking about? Why can't we have these exhibits? That's basically what I said.
And in the motion, you kind of relayed what had occurred off the record.
Went through everything.
Okay.
And that's kind of what this decision's talking about. the judge addressed my motion for clarification without notice to me when he was going to do it. He just did it, so I wasn't there.
Yeah.
I think Ed may have been in the courtroom. And,
Now, the good news is we started a minute late, so...
I think Ed may have been in the courtroom, but that's where the record came from, the motion for
Yeah.
clarification. Good question, Mr. Lynch.
Let me go.
Oh.
Slide off here so I can go.
Okay, so we're going to wind this up. We will be back tomorrow at 7 o'clock, and please join us then for AM News Network Presents The Morning Report with Rachel Baird and Ed Peruta. Have a great day.